in order for most of us to have that capability, if there's not a document in place and you're not in a position to authorize it, it means going to court. Going to court and getting a judge to have a hearing, appointing somebody, all this expensive machinery in place, time lost, money wasted, and somebody who's now reporting to the court and may not be doing what you would choose them to do. But the alternative is this form. A form.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. This is an appropriate time of the year for us to give some consideration to New Year's resolutions. And New Year's resolutions are generally about things that are really, really important. You know they're important, but somehow you don't get around to them. On that list, I think, are fitness, diets.
Losing weight, the typical ones.
Lots of things. I would argue that there's nothing that is more important than what we're going to address today in terms of recommendations for the new year for you. And that's easier to do. So this is more important and it's easier. And of course, you may have guessed what I'm likely to talk about, and that's you're doing some planning. But this is stuff that doesn't require a lot of effort on your part, but I can tell you, most people don't get around to it. The first of the year, as a New Year's resolution, we're suggesting that you follow the plan that we're going to outline for you, and that is designed to be easy. This has an easy button. Not a lot of stuff like this do. I don't know where the easy button is for fitness.
Yeah, or losing weight. I mean, and that's something that has to take place for months and months.
Yeah.
You know, and you're not seeing results right away. But
no.
With this, you do.
Yeah. That this is something where it is an easy button, meaning there are just some simple steps. So we're going to take the next, at most 45 minutes. We got to stay on schedule today. So we're going to, at most, be 45 minutes, but we're going to cover the checklist of the essential things that you need to get done to have your planning in place and to sleep well, knowing that all the most important things in your life are probably addressed on this list. So who else would we have with us today who can lead us down this important discussion? None other than Nina Windsor, who, as you know, is a partner with TuckerAllen. And so she's going to be leading this discussion. And, of course, Jill, you will be our person in the street asking those critical questions that our viewers cannot themselves.
The roving reporter.
Yeah. So,
okay, I can do that.
So you're an ambassador. You're an ambassador.
Oh, I like that better, ambassador.
Is this going to mean a pay raise? We need to talk about
I don't know. We're going to have to discuss.
Oh, yeah, we'll talk later.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
Anyway, now I'll hand the floor to you, Nina, to start us in this discussion.
So as we're, reaching the end of the year, I know we've talked about a lot of different things. I've gotten to be a regular guest here, and I really appreciate that. And we've
Our
hammered
legal
on
celebrity.
Thank you so much. But we have regularly covered topics that, in combination, basically have covered an entire comprehensive estate plan and some of those issues that come up as wrinkles, making that estate plan unique, even though we, still hammer home the point that every estate plan is unique. Every client is unique. So when we're talking about those things, though, the underlying concepts are pretty consistent between anybody who is coming through the door, regardless of age, actually, and regardless of family situation, the underlying documents that you need and the things that you need to put in place to have a full disaster preparedness plan are the same. And so because of that, we're able to actually kind of condense this down into a list.
We can. And I'm going to throw in, though, a comment that Nina may not completely agree with. But I would argue that if you're 50 or above, well, this is important for all of you. If you're 30 years old, especially if you have a child, obviously these things need attention. But I would argue that if you're over age 50, this is something that you just cannot responsibly put off.
Well, and I actually do agree with you. And I think that one of the things that we're noticing is that, let's say you come in and don't be embarrassed. Everybody should be there, when they're ready. And if you put things off, then today is the best day to try to take care of this. But if you come in and you're asking me questions about your parents at the same time as yourself, because your parents have not yet done things, then that means you've probably waited too long, because that means you're at the age that you really should be thinking about things, and they are far past the point where where anything could happen any day that could make things far harder on you. So at that point, the sense of urgency is really there.
It's pretty high. Right. Now, do you see, though, at the beginning of the year, more people coming in and thinking, okay, this is what I need to do? Do you see that typically?
I mean, they may have a mother like mine who's constantly harping on making sure everybody had an estate plan. My dad did the same thing. I think there's
Sounds
something
like she's
in the.
on top of things.
I think there's a provision in there.
Yeah.
Well, because anyone who has dealt with the death of a family member, especially if they didn't have a prepaid estate plan or a prepaid burial plan, so you're making all of those decisions, and then you're figuring out that as soon as you wrap up the funeral, you have to jump right back in to dealing with all of the things that are associated with a potential probate or tax returns and all the things that are associated there. And it's so much work that you don't get a chance to grieve. And also, if you have a family member who is incapacitated, then you notice very quickly, I don't have the appropriate powers of attorney for this person. So you may have had to go through a guardianship. So whatever happened in the last year or last couple of years, you may, someone in your family has had a either direct or tangential experience with a situation that could have been easier, but wasn't, because things weren't in place the way that they were supposed to be.
Because of procrastination, basically. Yeah.
So let's go through the list, or let's talk about some of these issues. And I do promise you, at the end of the show, we will go through we'll have pop up on the screen for you the list that we'll be talking about. But we want to, during the next few minutes, just talk about these items in more general terms. But I promise you the list at the end of the show. It'll be posted on the screen. So where should we start?
So I guess we can start out with, okay, you may have a plan, and it may not be the Cadillac of all plans. You may not have a full trust put together with all of your druthers, all of your preferences for how you would like things to go if you were either incapacitated or if you pass away. So if that isn't for you, or you've decided it's cost prohibitive, or you just refuse to go into a lawyer's office, you may or may not have a will in place. Remember that even if you do have a will, your will is your backup plan. You do not want all of your assets going through probate. It does nobody any good. So if that's the case, take a look and make sure that your accounts have beneficiary designations on them that go to the people that you want them to. Most likely, if you're married, your spouse is the primary. But it's surprising how many people I talk to that have their spouse as the primary and no one named after their spouse. I know that you don't think that your spouse is going to live forever, and I'm pretty sure that you know that you have no idea who's going to pass away first.
Right.
Even if you think you have a good idea, you may be wrong. So it's very important to have your contingent beneficiaries listed. Additionally, if you don't have powers of attorney, which we'll talk about as well, then at that point it may be good for you to have somebody on your account. Even though I really hate it when people add their kids to their accounts. But if you don't have a spouse and you don't have a joint account, it becomes that much more risky that at some point you're going to be incapacitated and nobody's going to be able to access those funds.
Right.
So just making sure, this is not your primary best plan. But if you're really trying to even get things in place until you can get into an estate planning attorney's office, looking at things today, make sure that you do have some sort of a plan, especially if you're traveling, over the holidays or over the new year, and you can't get into somebody's office. Make sure that you have a plan and somebody knows where your accounts are and things like that, where your bills are, what different types of assets you have, and try to compile them into one place.
Yeah, that makes sense.
Yeah. So let's talk about when we need to update. And I understand we should look at our estate plan like at least every year, right? So we're talking updating, marriages, divorces, births.
So let's say that you are the opposite of what we just discussed. You actually do have an estate plan in place.
Okay.
You have good documents in place, and you've spent good money on them. The hope, of course, is that you won't have to update them very often, but realistically speaking, the client may need to update, at least reviewing every 5 years. We recommend having an annual review with your attorney because including TuckerAllen, a lot of places will offer the opportunity to sit down and say, hey, what's new? And so your attorney at that point, would actually talk about those things with you, discussing whether you had any new kids or, whether a client actually had any type of divorce. We had an entire show talking about whether there was a divorce pending and whether you were thinking about a divorce. So if that's on your mind at all, absolutely go see an estate planning attorney. But I do think that for most people, a lot of things that come up over the holidays is that really having an accurate view over what your family is capable of and what the level of responsibility is of your of different children. As children become older, a person would start to see, okay, I have a client, I have a child who is really great with numbers and they're in school for accounting, but they were really young when I wrote my documents, so I didn't designate them on things. So I have had clients come into my office that have kind of reordered the way that they have their agents put onto their documents.
What duty?
Yes. It doesn't have to be an update of, I had dinner with my family and gosh, I really don't like this person and I don't want them. But that can happen.
That's a whole nother show.
But that's a whole other thing to decide that those are the changes that you want to angrily make. And even then we decide, we usually try to do a cooling off period before you make angry changes to your documents.
Right.
Yeah.
But if you are looking at any type of restructuring, it's a good time to look at your, at your documents.
Sure.
But I would say that for the average client, they're looking at, did they buy a new house that year?
I was just going to say that.
Did
it could
they
be a purchase.
Exactly. A big purchase, very exciting. A nice car that you don't want to end up in probate is another thing that you have to always take into consideration with your estate plan. But the other thing is that if you are looking at an estate plan that you currently have, it is very important to take a look not only about new assets, but also new accounts. And if you've changed jobs, if you've rolled over a retirement plan, any of the things that can be seen as really exciting, positive changes, they come with paperwork. So if you are not a paperwork person and nobody in your family is a paperwork person, then you can take your stack of things, your shoebox, whatever it is, but bring it into your attorney's office and sort through it.
So, but also, there can be some unfavorable changes like a medical diagnosis that, how often does it happen that we have that?
Very sad. Actually, this month, and obviously we won't name any names, but we have had several consultations that have been on a rush. Unfortunately, not because the rush for the documents was I'm leaving to go to Europe, although that happens too, and we love rushing around for people to go on vacation. But unfortunately, we've had some rushes on documents because of somebody who's gotten an unfavorable diagnosis or a prognosis, and we want to make sure that since they've taken that big step to come in and try to get things done, that we beat the clock on that. So maybe they'll, maybe things will go better than we think that they will, but if they go worse than they think that, they will, then we want to make sure that the documents are in place for them.
And that's an important distinction. It doesn't mean that you might or a family member might have gotten a terminal diagnosis. Matter of fact, you may even be encouraged. The doctor says, look, this is a malignancy, but I'm confident, reasonably or even strongly confident that we can treat it, and they probably will. But that's an example where, just this new risk factor has been thrown into your life.
Yeah.
So it doesn't mean just a terminal diagnosis. It can just mean that you're having this brush with something that could be life-threatening, probably won't be in your case. But that's a good reason to think about, any revision you want to make in the plan.
You want to be proactive with something like that. You don't want to sit around and just hope for the best.
But so many people think that a medical scare is just a medical scare, meaning or a medical crisis. But it's more than that. And by some value systems, by some of your value systems, there's something more critical even than the medical care itself to you. And that's other priorities you may have in your life, and things largely that can be addressed through the sort of things that we're discussing here.
Right.
So don't think of a medical crisis as being nothing more than that. Everybody hurries to go to doctors, as you should. And they do research, as you should. And if they need to get on a plane and fly to get better care, so be it. Thankfully, if we're in St. Louis, we probably don't have to get on a plane.
No, we've got world-renowned hospitals.
Yeah. But at the same time that you're doing those things, I'm arguing to you that these things should be as important or almost as important as the things that you're doing to take care of your health.
And one thing I would like to add, because I think it's very important, and it kind of surprised me, that some of the hesitancy people have when they have a diagnosis towards estate planning is they think of it as the same thing as picking out their casket, which I know that you've had other shows on and can be very helpful, but somebody else can probably pick out your casket if you have a mental block for not being able to pick out your casket. No one else can notarize documents for you, granting authority to handle your affairs.
Right.
So it is not designed to be morbid. It is not designed to be you throwing in the towel. It's not bad luck to put these plans in place. And when we're talking about things with clients, we are very careful to discuss things in terms of best and worst case scenario. So that conversation was going to happen that way, whether you came in with a terminal diagnosis or not as a client.
Right.
Mm-hmm.
You can have any type of condition. You can have any type of worry about your personal situation as a client, and it does not matter. We're going to ask pretty much the same questions, but we're going to dig into them as much as you allow us to offer those preferences to be documented as much as
just
possible.
Covering all the bases.
Yeah. Most people have more specific thoughts about how they want things to go when they have really contemplated their mortality, but it is so on the attorney side, it makes it a little bit easier to really get a specific document in place. But I mean, we're going to go there regardless because we want to make sure that we have a good product that's not cookie cutter.
Well, since we've hit on medical care, can you take a few minutes and talk about a durable power of attorney? I guess we should talk about it generally as well as it pertains to medical care.
Yes. So we've gone through this year about medical powers of attorney versus financial powers of attorney, also known as durable powers of attorney. So for healthcare documents, some people have documents that encompass all three, both of a HIPAA, a living will, and a document that grants that authority to someone else to make medical decisions if they can't make them for themselves. Sometimes those documents are all split up. So you'll have 3 different documents kind of in a packet that you will hand to the hospital. None of those are a DNR. So again, it doesn't have to be
You're
super
going to have to explain DNR.
morbid.
DNR.
Do not resuscitate. So someone who's talking about whether they want a ventilator support or artificial nutrition and a feeding tube, that's going to be in your documents. You're going to talk about that if you come in and you're 18 or if you come in and you're 93. So it's going to be there. But that is not the same thing as telling someone not to bring you back and to use paddles or whatnot to bring you back to a certain stable state if you were to lose consciousness. So again, it's not that morbid. We're not assuming that you're so sick that we don't want to actually try to take care of you and direct the hospital to do that. It is a very good document to have in place because if you cannot make decisions for yourself, even while you're in surgery, you need to have someone that can. And if you are single, whether that's because you're, widowed, or because you're just a single professional, or whether you're a college student, you should have something in place that grants that authority to someone else, because there is no default authority granted with a healthcare power of attorney unless you're a kid.
Mm-hmm. So you need to think about somebody that you would trust with your care over what could be decades. And I'm talking about just medical care, health care.
Right.
That's the durable power of attorney for health care, which is different from the general durable power, which is legal matters and business matters. But the one relating to health care, which is what we're talking about here, if you had a stroke, if you became incompetent, something such as that, that person would have the authority to make all the decisions about your health care for you. And that can be a fairly long-term role for such a person. More often than not, this comes into play at end of life, but it could come into play, a decade before end of life. So it's really important to think about who would be in that.
Right.
Talk about how often you see, or do you see often the person who's chosen to have the durable power to also have the general durable power?
So for most clients, they will elect to get both documents. There's no reason not to take care of a financial power of attorney at the same time as you're doing healthcare documents.
Do they choose the same person typically?
But as far as who you choose for an agent, most of the time they will choose the same person if they only have one child, and if they have a spouse, it's usually the spouse for both. But as your backups are concerned, if they only have one child, they'll usually name their child next. If they have multiple children, it's very interesting to see whether they will name the same person for financial as healthcare. In my family, we have certain people who are in healthcare and other people who are paperwork, numbers,
Right.
budget people. And so in our family, even amongst the siblings, we name our different siblings for different duties.
But you want to have a succession plan, because if
Yes.
the first person, for whatever reason, passes away, then you have to have someone else to fall back on.
Yes. So, if your New Year's resolution is to get in and get all of your documents taken care of, get the most for your money, and make sure that you don't just have one person named, because that way you've got your backup plans and you don't have to come back and add them later.
But you don't, and I know this does happen where someone might have, 2 or 3 people, say their kids, serving in that same role. That's not a good idea. Simultaneously, yeah.
Well, we've talked about how much I don't like co-agents.
Yeah, because too many cooks in the kitchen. They may not agree.
They may not agree. They may also want to agree, but be second-guessing themselves or each other, and it's just very difficult. Mm-hmm. And then on top of that, the person who is on the receiving end of that document has to make a decision whether to take one person as having authority for both. And so if you have one person as a physician, let's say, you have one family member who's on there in town and communicating with you, but the other person is out of town, there's a lot of concern over just taking one person's word for it. And so it can slow things down.
Right.
The whole point of these documents is to speed things along, to make them as seamless as possible so that you are getting the best care as a person who is granted this authority.
Mm-hmm.
Yeah, and I don't think that you should have any reluctance to name 2 different people, because it is, if we think about our world experience, there are people who we think of as nurturers, and there are people we think of that are maybe better at managing things. And I can think of my 2 daughters who both are smart and gifted and whatnot, but one is a little more nurturing. The other, if she weren't a lawyer, she'd be an accountant, I suspect. So, just different skill sets. And think about who would have the skill sets to handle the business matters, et cetera, and then think who might be more appropriate for the tender sort of side, which is the caregiving side. And most people do have, I think you agreed with this, that most people do have 2 different people in that role if they can. But as you said, sometimes you don't have two different candidates. So you choose one person, and that's fine. But think about the successors. And most people, I'm sure, name their spouses first, right?
They do.
And remember, that's somebody who's probably close to your own age. And there's a good chance, I read this statistic once, when husband and wives die together.
We talked about that.
Yeah, it wasn't a big number, but it was a big enough possibility to where, you travel together when things happen. Sometimes they happen to both of you. So it's good to name your spouse first if that's the person you would choose. But then, as we've said, you've got to have successors and name 2 or 3, and that means that it won't be slowed down. And as we just discussed too, it's better to have in place Nina's recommendation that you have one person if you can, because that person is going to be able to make decisions and move things along. If you have 2 people that are required, then of course there's always the possibility of a deadlock, and then you say, well, maybe I need an odd number, I'll go to 3. But the problem with that is now you have to locate 3 people somewhere on the planet, and it's not like 100 years ago, and there's a good chance they're within a quarter mile of each other.
We're spread out now.
There's a good chance that maybe they're not even on the same continent. And you want decisions made immediately so that your care is streamlined and financial counts, et cetera, for the role of the durable power of attorney, the general power. So anyway, I think, have we covered this enough, or is there anything? What else would you add, Nina, to this, if anything?
Just making sure that you're revisiting powers of attorney and making sure that they still encompass everything that you want to give authority on. Newer powers of attorney documents will normally include provisions regarding electronic and digital assets. So if a power of attorney document was prepared prior to 2005, even 2010, it may not include these very important provisions that have to do with accessing things that are electronically held, such as photos and even financial assets, like cryptocurrency.
Cryptocurrency. Oh, we've done shows on that one before.
Yeah.
Yes, maybe we should do a show on FTX.
Don't really love it.
As a retirement
Oh, yes,
plan.
yeah.
So one other thing, though, I think I think you would agree with this from what you said a while ago. So if our viewers could only get one thing done, maybe they don't have much money and they wanted to know what can I do cheaply and get the most power for my buck? What's the phrase?
Bang for my
buck.
Bang for my buck.
So would you say that the most power you probably obtain or the most benefit for your buck would be through the durable power?
Yes, I would. Because it also doesn't require you to think in this way that, you're trying to think about your end of life. This is talking about something that could just be you're taking an assignment out of the country and you want to grant somebody power to take care of things. You want to you're traveling just generally quite a bit, and any international hospitals are going to want to see that authority on those documents. So, anything that is normal, day to day as a retired individual, just to make sure you're covered, all the way down to you have this very high-powered, busy lifestyle. Anyone over the age of 18 needs powers of attorney.
Yeah, and I can't pound the table enough on this thing. I mean, I've said this since we started this show, that all of us are wandering around with a substantial risk that we'll not be able to make decisions in the same day, at the end of the same day even. Because when you travel, your example, especially you'll be in a car wreck. It doesn't mean that you're going to die. It doesn't mean even that you're going to be out of service for maybe a long period of time. But it could just be serious enough to where you need somebody who's empowered in the United States to do everything that you need done, whether it's getting documents transferred, whether it's getting authority through your insurance company, whether it's accessing money. Some of these countries, depending on where you're traveling, you may need to wire cash. And just think, in order for most of us to have that capability, if there's not a document in place and you're not in a position to authorize it, it means going to court. Going to court and getting a judge to have a hearing, appointing somebody, all this expensive machinery in place, time lost, money wasted, and somebody who's now reporting to the court and may not be doing what you would choose them to do. But the alternative is this form, a form.
Yeah.
And I say form. I don't want to oversimplify that. There are some important decisions to be made, but they're not real complicated decisions. There's a list of questions that you can be asked in a 1-hour meeting, maybe.
Yes.
So I mean, this powerful, powerful piece of paper that's probably not more than 5 pages, less. Don't tell me you have 20 pages.
It's not 20 pages.
But it's more than 5. Anyway.
Somewhere in between?
Yes.
It's comparatively inexpensive. I less than $1,000, certainly.
Oh my goodness, yes.
Yeah,
especially as a single individual.
Yeah, less than 500 maybe. But I corrected myself a while ago, lest I prompt you to think that if you know somebody who has one, you can run off a copy and sign it yourself, and you're good.
Please don't do that.
The same thing goes with wills and trusts, but. There are some important things you're going to answer that yours will be different from other people, but it's not as complicated as doing a will or a trust. And as a result, you can have something like this in place and spend less than $500. So that would be, if you're only going to do one thing on this list, it'd be that. So what should we get to now? Things to do in the month of January.
Our to-do list.
Our to-do list.
Without further ado.
So some things that you should take a look at if you are looking at your New Year's resolution, start with your attorney, because if they're a good attorney, they're going to be able to see where the gaps are. So if I'm talking to a new client, I'm going to ask questions like, do they have a burial plan? Do they have life insurance? Do they have long-term care? So if the average person is coming into an attorney's office, that may be their first time discussing any of these topics, but they also may not know that it's relevant that they have a CPA who regularly does their taxes, or that they have a point person that deals with their retirement plans or their brokerage account. We talk about all of those things with anyone who comes in, not only to get a baseline of where their finances are, but also to make sure that they know that the door of communication is open with those other professionals for us to give and share information. And so I always ask whether we have permission if we get a call from one of their professionals to share what we're working on. So some of the things that need to be done, such as talking about where those retirement assets are going to go, and whether they go to a spouse first or whether they go to a trust, or how are they going to be structured for distributions. Those are things that we handle. But who is holding those other accounts and whether that person has questions as to how those things are going to be handled through the estate plan or has input. They may know a special circumstance that the client is not telling me. So the most important thing is to make sure that you come in with an open mind. Nobody is trying to give you information that's going to cost you extra or anything like that. When you're working with an estate plan, it's not more expensive to have your estate planning attorney, if they're flat rate, communicate with these other professionals because they're not charging you hourly.
And that's what's great about estate planning, unlike if you've been in other areas of the law, like litigation, where you're billed hourly.
Mm-hmm. Absolutely. So if you are somebody who's looking for an estate plan and you're comparing different attorneys, it's a good idea.
And I think that you've touched on what I think for many people is the deal killer in terms of their getting this done. Is they imagine that they're going to have to meet with a lawyer. The estate planning lawyer will say. Then the estate planning lawyer is going to ask them things and ask for things that you don't have, but you have a tax lawyer or a financial planner or an insurance agent or something that may have that information. So you're thinking that you're going to launch into a series of errands in which you're going to be running documents between professionals which you don't understand, and each of these professionals will be in their own silo asking you questions and asking you to interpret what you were told by another professional which you don't understand. So it produces such anxiety that you say, I think I'll maybe do that next year. So what we want to emphasize to you is Nina's approach through TuckerAllen is to be that professional in the center that coordinates everyone and allows them to function as a team. So rather than a series of silos, they become interactive, believe it or not. And so after you leave your meeting and you go home and go about your life over the next several weeks or whatever it may take, these communications, if you've given us the authority, these communications are taking place. So you're not worrying about our knowing what the tax lawyer told you, thinking that we're going to screw up the tax plan, or thinking instead that your insurance guy is going to screw up the plan we do. Instead, we can assure that everybody is on the same sheet of music and we're all playing the same thing, and you don't have to worry about it. So
I like that same sheet of music, and we're all playing the same thing.
Yeah, but that's the only way that you can do what Nina's talking about. Is there's more than one professional involved, and you're not capable of being the interpreter. We know that, so we're happy to do that. How does that normally work?
Well, a lot of the communication will happen after the estate plan has been drafted. Some clients will ask us to send a draft to their person who's, their coach, their financial advisor. We deal very, very closely with financial advisors. Sometimes the financial advisor actually refers the client. And again, they don't get anything for doing that, nor do we get anything for referring a client to a financial advisor.
That's an important point to make. You should know this, and you should ask it of any professional who purports to interact with other professionals on your behalf. Are they getting paid anything? I know this sounds cynical, but I believe if you get truthful answers, the substantial majority of the time, there's some sort of compensation. And I can tell you, for lawyers, ethically, we're not supposed to, number one.
Correct.
But for TuckerAllen especially, we're emphatic about that because we know that that's what gives us credibility with you, is that when we suggest you talk to this tax lawyer, or we suggest I don't think we'd suggest an insurance product. Maybe we would suggest that you have some life insurance. Certainly. You can be sure we're not getting paid anything to give you that advice other than the flat fee that you've given us.
Correct. There are no contracts for partnerships with any business. We've been approached for that, and we have declined.
Yeah, it's really cleaner that way.
Yeah.
But
that's good to know for the client.
It really is.
It really is.
It shows that we have a level of concern that maybe a regular accountant might not have, or a different type of a firm may not have, that we really want our documents to work well in, but for your whole plan across the board through retirement, after your passing, after one of the passings of a couple, that things go the way that we're talking about. Exactly.
And if you think about it, it's really a natural arrangement. If I were to ask you to think about that circle of professionals who we agree, need to interact, I'm sure you agree with that, and we need to be coordinated, and you probably agree that somebody should be at the center of that other than you, then if you go down the list, we're the natural, this professional, meaning your estate planning professional, is the logical choice. You wouldn't choose your tax lawyer, because your tax lawyer would really is just very narrow in terms of their perspective. It's just tax. Estate planning affects all your assets, all your life, and your health care and other things. So it's a large umbrella. But your insurance guy, you wouldn't say, "Oh, this is the person I want to interpret."
No, definitely not.
And they would defer. No. They'll ask you if you have an estate planning attorney.
I'm sure they would.
Now, your financial advisor may say, "Oh, that's me." But I mean, if you think about it, I don't think you would conclude that that's probably the rest. It's not that they're not authorities on investment, but they'd have to understand the legal dimensions. So the logical choice is your estate planning lawyer. And if you go to somebody other than TuckerAllen and they don't do that, you should ask them, I need somebody who can play that role, because you don't want to be the person in the center. You end
up feeling like a ping pong ball, and this happens to me professionally sometimes as well. So you just want to make sure that you don't have that happen. Nobody likes it in their personal life, being the interpreter between a bunch of different people, and so they clearly aren't going to like it with something this important.
Yeah, exactly.
So, yeah.
And that really takes, a few things off of your list that you're going to want to to take a look at if you're somebody who is looking at trying to make sure you have a comprehensive plan. I mean, I can't go pick out a burial plot for a client, so they're really going to have to do that themselves if it's something that's important to them. But it doesn't have to happen right away.
Right.
Or they may be cremated.
They may want to be cremated.
That's more and more.
And or green burial, which we're drafting all kinds of things. So if you're putting together a set of documents as a client, they may want to actually look at just putting a general intent as to what would happen after they passed away. Mm-hmm. And then there are other documents that can be more specific. So you really, as an individual, don't have to make all these decisions before. And also, there's a waiting period in between. When a client comes in and says, I want to get something down on paper, that's a draft. That is a definition of a draft. It's not a final document. So when I'm working on something and then I hand it over to a client, I'll often have spaces where I said, hey, we had a TBD, to be determined, on this particular point. Have you thought anything more about it? Have you made some phone calls? And they will respond, I'd like to keep it vague, or yes, I did make that phone call. I'm going to have paperwork that I bring with me to the signing of my documents, and we will incorporate that. So there's no reason to delay for taking the first step to get something roughed out.
Sure.
So I know we're running out of time. Before we wrap up, I want to be sure, though, we get to the pour-over will. The pour-over will works in conjunction with the living trust. Can you take just a couple minutes and remind people why they do that?
So one of the misconceptions about having a trust, people will get very frustrated and say, I thought I didn't need a will. I have a trust. So again, we're talking about disaster preparedness. We want to have a plan A, a plan B, hopefully a plan C. So your plan A, when you have an estate plan, is going to be your trust. But for a person who has a trust, they also want to make sure that they have a will. And the will does not have provisions in it that says to so-and-so they get my car, and to so-and-so they get my chess set. A pour-over will is something that pours your assets over into your trust if you forgot to designate them appropriately to your trust before
it's like a
the
safety
person
net?
Passed away.
Or a backup plan?
It is. It's a very good safety net. It will name your, the trustee of the trust will also be named as the personal representative. So it looks kind of the same as far as who somebody is designated as their fiduciary. It's a very simple document. It says to the court that that person can serve without a bond, that they don't have to have supervised administration. We can always go, through that at another time with what the statute says. But what it is let's simplify this process as much as possible. Yeah. We didn't even want to have to use this document to begin with. So this document is basically going to say, probate court, please issue an order saying that asset that someone forgot to put into their trust goes to their trust. And then it's kind of like the marble game. Places that asset up at the top of the marble game, and then it bounces around according to the provisions that the person has put in their trust.
I've never played the marble game. Have you played the marble game, Jill?
Oh, it's
my
been
grandparents
years.
had a marble game.
I loved marbles.
I'm trying to decide if I'm too young or too old to know what that is. Usually I'm too old. So
not in this instance.
Jacks, that's a fun game too.
But it's really,
I know that game.
You have all of the provisions that are in a trust that someone has spent a lot of time making decisions about. And then they're like, well, now I have to make all these decisions about this will too. That's not true. You've made all the decisions already. They're in your trust. And this is simply a document that is saying that if you went out and bought a car and passed away a month later and didn't put a designation on that car, that it was going to go to a trust that the probate court can take care of.
So that's a way to think of it. I like that phrase, a safety net. It's something that will capture any asset that you didn't know about. I mean, you could, if you are predisposed to walk a high wire without a net below you because you know how to do it and you know you did it, you're doing it correctly, then, there's no law that says you have to have a pour-over will. So you could not have a pour-over will and say, I'm confident, I've got it, all my assets are in my trust. So it's not required, number one. But it's really crazy to not have it because there's always the chance that, if nothing else, an asset you didn't even know about. So it wasn't that you forgot to put it in, you didn't know about it. So maybe you had inherited a bunch of money from some law, or you want a publishers clearinghouse, whatever it is. There could be some source, a lawsuit in which you're named in a class action. You didn't know about it, maybe, or didn't follow it. So it's really silly to not. A pour of a will is so simple, and it's this incredibly effective net, so that anything that wasn't in your trust, it's caught and it's put in your trust. So it's simple as that. I think that we've covered, have we gotten at least mentioned each item on our list? Because I'm going to let you summarize the list real quickly. The list that we're posting for you all is going to have how many items do we have? 8 items. And I think those are all self-explanatory. Do you want to go down that list real quickly?
Sure.
Just say what they are.
So our wrapping up list for things to take care of in the new year or before, depending on how proactive you are, is to make sure that if you have not gone to an estate planning attorney's office, that you at least make sure that you have beneficiary designations. If you are doing an estate plan, make sure to get a revocable living trust in place that will allow you to make decisions for your assets and to be very, very specific. To combine that with your backup plan, which is going to be your pour-over will. And then, again, going back with those powers of attorney, make sure you have those powers of attorney. If nothing else, get those in place. If you need to worry about getting your trust in place later in the year, that's fine. Along with the powers of attorney, make sure that you have a living will that is in conjunction with your healthcare power of attorney, allows you to make any type of end-of-life decisions and for you to make direction on how those are made, not making it so that somebody has to guess what your wishes would be. And then when you're talking about making things, wrapping things up, bringing them full circle, you're going to want to take a look at your funding, which we had called beneficiary designations. If you did take care of having a trust, make sure that all of your assets are pointing towards that trust. That's usually a form that you're going to get on each account. And if you have a good estate planning attorney, they will be able to confirm that you have the right form and be able to help you out with that. Burial plans. We touched on that briefly, just seeing that if you are interested in getting a burial plan, make sure that your estate planning attorney knows about it. And then also long-term care and life insurance. If you don't have someone that you like working with, your attorney can most likely give you a recommendation of someone to work with, again, without any type of compensation, but kind of point you in the right direction and coordinate with that person.
These are the incredible 8 items. If you get these 8 things accomplished, then you're good. You're good as to the most essential things in terms of your planning. And I place this in front of all these other competing things that you have in your life, all of which are important, don't get me wrong. But these 8 items you can get done within the month of January.
And you're
if you
off
start
to a good
early.
new year.
Yeah, you could get it all done in the month of January. Is that possible if they came in early?
Absolutely. You can get it done within the period of a month.
Yeah. And meanwhile, you don't have to worry about communicating with the other professionals in your life. You don't have to worry about it. You can let your estate planning lawyer worry about that. And it's included essentially in the fee because it's a flat fee is the way this area of the law is built. So with that, we wrap up an episode that was dedicated to the best New Year's resolutions you could have for 23.
Wow, 2023. I can't believe it.
Boy, that year went fast, didn't it?
It did.
Yeah. All right. So this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.